May it please the court, my name is Onor, initials NO, and I am here to represent the defendant Lynn Bacco, a 14-year-old Aboriginal girl from Townsville, charged with 5 counts of breaking and entering premises and committing an indictable offense under Section 421 of the Criminal Code and 1 count of attempted arson. Your Honor, before we address further proceedings, I would like to question the validity of the admitted evidence. The circumstances in this matter are as follows. My client, an indigenous juvenile, was apprehended by the police for interrogation without consent and subsequently placed under arrest. The defense submit this application by way of Section 590 capital AA, subsection 2 paragraph E of the Criminal Code to seek the court to exercise its discretion in excluding the Crown's evidence relating to the confessions made by my client during the time of her arrest and during the interview at the police station. The Crown's evidence should be excluded on 2 grounds. First, the application of the fairness discretion decided in the cases of Christie, Hasler, and Lee, wherein the probative value of the evidence is insufficient as opposed to its substantial prejudicial nature, thereby placing my client at risk of improper conviction. Second, the application of the public policy discretion, decided in the cases of Crown and Ireland and Bonning and Cross, wherein the admissions generated from my client were obtained in contravention of multiple statutory requirements under the Police Powers and Responsibilities Act, hereinafter referred to as the PPRA, therefore contravening public policy. With regards to the fairness discretion, the admissions relayed by my client were gathered through a culturally insensitive interview process which did not take into account the method of communicating amongst Aboriginal people, specifically the use of gratuitous concurrence or the often affirmative response to indicate respect or unfamiliarity or when the interviewee is under duress. In this instance, Your Honor, there was clearly a demonstration of gratuitous concurrence because my client of Aboriginal descent was intimidated by the police officer who used numerous leading questions resulting to the charges made. However, these affirmative responses are neither an absolute admission of guilt nor an indication of an understanding of the consequences of the answers. If admitted to evidence, on balance, this will therefore be more prejudicial than probative. Hence, may I request the court to exclude this evidence. With regards to the public policy discretion, it is submitted that the Crown evidence be excluded because of the police bypassing the required procedures by not complying the legal obligations under the relevant sections of the PPRA. There has been an apparent corruption and irregularity. Section 418 states that before starting to question persons, a police officer must inform them of their rights to speak to a relative, friend, or lawyer and must delay questioning until this happened. My client was not afforded this right, amounting to a clear breach of duty. Section 421 also relates to the questioning of the child defined in the Schedule 4 of the Youth Justice Act as a person under the age of 17. My client is just 14 years old and should have been allowed to speak to a support person chosen by her. And when she was apprehended, initially she was questioned without being afforded an opportunity for support. Whilst a support person was called upon in the police station, this person offered was not chosen by my client and did not offer a suitable support mechanism sensitive to the needs of my client, as evidenced by merely emphasizing the need to answer the police questions as the police were just simply doing their job. As mentioned previously, my client is an Aboriginal juvenile person and falls under the category of a special witness according to the Section 21 capital A of the Queensland Evidence Act. Therefore, Section 420 of the PPRA applies. Under the requirements of the legislation, the police officer has failed to provide my client the opportunity to access a lawyer or a legal aid representative. Given the circumstances of the case, there should have been an apparent reasonable suspicion that my client was at a disadvantage compared to the members of the Australian community generally. However, this was apparently disregarded. In conjunction with Section 421, the police should have practiced a greater duty to abide by the PPRA. In assessing the significance of the breach, I would like to direct the court to the case of Crown and L, a Queensland District Court case with similar circumstances to the present scenario. Here, the court held that a field officer for Aboriginal legal aid was not a relevant support person because they were not chosen by the defendant, and ruled that evidence as inadmissible. Your Honor, the defense submit that this ruling be followed. Further breaches are demonstrated by not cautioning my client to the choice to speak freely or to remain silent under Section 431, subsection 1 of the PPRA and Section 26, subsection 1 of the Police Powers and Responsibilities Regulation. Instead, my client was informed to answer all questions asked by the police. In relation to the record of interview, the defense submits that Section 436 subsections 2 and 4 of the PPRA have been breached, as the record of my client's interview contains several sections that are just listed as inaudible, a clear proof that the right procedures for this interview have not been followed. The defense would like to direct the court now to the 5 factors which inform a decision to exercise the Bunning and Cross discretion. The breaches mentioned were done deliberately, and despite the cogency of the prosecution's evidence, its probative value is largely diminished by the repeated breaches of the police who was conducting his duty not in response to a pressing circumstance. Also, my client was not charged with a highly serious offense. The purpose of the PPRA and the PPRR is to protect individuals from unfair and unlawful treatment. Here, the Crown's evidence was gathered through multiple unlawful breaches, and therefore we ask the court to exercise the Bunning and Cross discretion to find the evidence inadmissible. In conclusion, both the fairness and the public policy judicial exclusionary discretions should apply. That completes the defense's verbal submissions. Thank you, Your Honor.